Hello and welcome to this webinar on estate planning that protects assets against long-term care costs. Hi, my name is Lynn St. Louis. I am an estate planning and elder law attorney with ELG Estate Planning. We serve clients in Spokane, Tri-Cities, and Seattle. So today what we're going to be talking about is estate planning, long-term care costs, the Medicaid benefits program, and how all of that ties together. Now, my goal is to provide you information that allows you to understand basics of estate planning, basics of Medicaid, and basics of how they all fit together. I say basics, but I have to let you know it is a pretty complicated area when you are talking about Medicaid and Medicaid long-term care benefits. But I'm going to do my best to make it understandable. One of our goals at ELG Estate Planning, in addition to serving clients, is to providing education. So I'm glad you're joining me today. If you have any questions, feel free to put them in the chat or in the question and answer session. So without further ado, let's go ahead and get started. So I am going to share my screen a little bit today. And what I'm going to first be sharing with you, and I hope you see this, is estate planning basic documents. So I'm not going to be talking about a lot of details on each of those documents, but before we can really talk about documents that protect assets against long-term care costs, we need to know, well, what do those basic documents look like? So, durable powers of attorney for finances and for healthcare. Those are really important documents that have been drafted with the idea of protecting assets against long-term care costs. We'll talk about what does that look like. Also, your healthcare directive and your living will. That's the document that says what you would want if you are at end of life. What kind of medical treatment do you want? We're going to be talking about wills and revocable living trusts. Those are two basic ways that people will transfer assets upon their death. A will takes effect only upon death. A revocable living trust takes effect when you sign it during your lifetime and then continues after your death to direct where your assets go. Now, within wills and within revocable living trusts, there are subtrust or different types of trusts. Trusts can protect against unnecessary estate taxes. Both a will and a revocable living trust can do that to make sure that upon death, the person's credit shelter exemption amount is taken advantage of in Washington State. What we're talking about is a 2.193 million amount of assets that can pass on somebody's death without being subject to Washington's estate tax. Now, there is a federal estate tax, which is much higher, $13+ million, at least as of this year. There are changes in the works with the federal estate tax, but we are just going to go with what it currently is, $13.61 million. And what I'm going to be talking about and showing you also is how a will can protect against long-term care costs. So the will can protect against long-term care costs for the benefit of another person. It's your living documents, your durable powers of attorney, especially for finances, that can protect you against long-term care costs while you are alive. So I want to make sure that we also talk about estate planning that is not covered by a will. So a lot of times people forget that there is a very important component of estate planning, which is their assets that go by way of means other than your will. So for example, account titling. Maybe you have an investment account or, a savings account or something, and it's titled in your name and in somebody else's name. And it can be titled with rights of survivorship. And if it's titled that way, then the person who is the joint owner is going to be the recipient of that account upon your death. It won't go under your will or under your revocable living trust. So it's really important to be aware that there are assets not governed by your will. Same thing with life insurance policies or retirement accounts. Those pay on your death by way of what's called a beneficiary designation. So a beneficiary designation says where those assets go. Also, it's important to understand that certain assets cannot be titled in the name of your revocable living trust, such as your retirement account, your 401k, your IRA. So when you're thinking about what your estate plan looks like and you have a revocable living trust, make sure your beneficiary designation is in place on your retirement accounts. And with respect to your other assets that can be titled in your revocable living trust, they should be, because that's how the trust works. It has to be funded for it to control assets. The assets need to be within that trust. So I want you to be aware that sometimes, why it's important to have an understanding is you got to understand how these components all fit together. So I didn't spend a whole lot of time talking about a revocable living trust, so I'll just take a moment to do so. To clarify, most people understand what a will is. When actually most people think, oh, I need an estate plan, I need a will. It's true, you need a will, but you also need those other documents that I've covered, the living documents. Do you need a revocable living trust in place of a will? It depends on what your situation is. But part of what we're going to be showing here today is how a revocable living trust is not advantageous when it comes to protecting assets against long-term care costs. So we will be talking a little bit more about how each of those documents operates as we move forward. So let's move from this very quick basic discussion about estate planning documents. Don't worry, we will get to how to protect your assets, to what are we trying to protect your assets against? And for many people, especially for the majority of people who we meet with, who are retirees and they're, looking at what does their financial future look like, a big concern is long-term care costs. And why is that? I think we all know why, because it's expensive. It's very expensive. So you can be at a skilled nursing facility and it costs $15,000 a month. You could be at an assisted living that costs $8,000 a month, or an adult family home that's very similar. Or you could be at home and you need help with your activities of daily living. So what are you paying at home? It can run the gamut from $1,000 to $2,000 a month, all the way up to even beyond a skilled nursing level. So understandably, people are concerned when they are looking at their financial future. What can they do to protect themselves and their assets so they don't need to worry about how their care costs will be paid? I will share with you this next screen right here. How do you pay for long-term care costs privately? Most people spend down their money. There's also long-term care insurance, which statistically only a minority of people have. I think long-term care insurance makes a lot of sense, but oftentimes people didn't buy it in their 50s or 60s when they were medically eligible. And even if they did, it could be cost prohibitive to have that kind of insurance. So it definitely is a great way to protect your assets, but does it work for you? that is something that you need to answer. I did include in this slide here the Washington CARES Act because that is a newer insurance benefit program that we do have in Washington State. I'll talk about it very briefly. There's also veterans benefits that a veteran might qualify for. Medicare, does Medicare pay for long-term care costs? Question mark? No, the answer is no. Medicare will pay for rehab when somebody leaves a hospital, goes to rehab before they go home or wherever they're going to, but do not think that Medicare is going to cover your long-term care expenses because it won't. The biggest payee or source of payment for long-term care costs is Medicaid. So with Medicaid, and then we're going to be talking some Medicaid basics to help you understand Medicaid better. I just want to point out that the Washington CARES Act, well, I think it is a great idea to start and have an insurance program. It only covers currently a lifetime benefit of $36,500. $36,500 could be 3 months in a skilled nursing facility. So it's really not that helpful when it comes to real long-term care costs. Definitely it's a step in the right direction, but it's a baby step, and it is not going to prevent somebody from becoming impoverished if that's all they have. It's a new act. You get the benefits after you paid into it for 10 years. So that's for the future. Will there be adjustment by the legislature to the CARES Act? Probably there will be. Will it become more robust or more anemic? Time will tell. But it's not something that you're going to rely upon to protect your assets against long-term care costs. A little bit about the Medicaid program. It is a state and federal program in that they work together with funding from both. Medicaid will pay for care in a skilled nursing facility, as a nursing home, assisted living, adult family home, or even in your own home. That's under what's called the COPES program. In order to be eligible for Medicaid benefits, you need to qualify medically, meaning you need the care. You need to qualify from an income test and from a resource test. And it is the resource test that really is the more challenging limit for people to overcome. So medical eligibility basically is, do you need help with eating, bathing, dressing, transferring, toileting, walking, moving around, or do you have a significant cognitive deficit? If so, medical eligibility will be met. Medical eligibility is usually the easiest test to meet. Medical eligibility is determined by a care assessment by a DSHS social worker. Financial eligibility, two parts of that. There's an income test and there is a resource test. So financial, there's two pieces that you need to take a look at. So let's start with the income test for financial eligibility. For skilled nursing, basically the rule is that your income has to be less than the cost of care in the facility. So if it costs $12,000 or $14,000, if your income, you're the person going into the facility, is less than that, then you meet the income test. Usually that's not a big hurdle. There is a program that's called the Community First Choice, which covers care at home or in an adult family home or assisted living. And the income standards for that are much lower. For in-home care, it's $943 currently. And for care in a facility, it's 3 times that, or $2,829. And this is gross income. So if a person's income is less than that, then Community First Choice might be an option. If their income is more than that, but they need care at home or assisted living or adult family home, then what you're going to be looking at is the COPES program, which stands for Community Options Program Entry System. But COPES is what we call it. The income standard for categorically needing, which is, don't get bogged down in that. It's the same though, 2,829. But what's really important to understand about the COPES program is that the income limit, the high end of the income limit is $10,387 plus potentially even higher than that. So it's a very high income standard. And if a person has income of $10,000 and their adult family home is only $6,000, they're not even going to be thinking about the Medicaid COPES program, probably because they can privately pay for it and they still have money left. But oftentimes it does make sense to apply for the COPES program, even if the income is higher. As I mentioned earlier, I'm trying to provide like broad information for education. When it comes to specific questions about, should I apply for the COPES program? Should I apply? Should my spouse apply? What should we do? I can't answer that, but I can provide you basic general information, and that's my goal here. So when it comes to the more difficult financial eligibility tests, that's the resource allowance. And for Medicaid for single people, it is an impoverishment standard. It is $2,000. That's all the Medicaid client can have if they're single and they are going into care. There is a very quirky exception to that rule. If they're under 65 and they're going into a skilled nursing home and they haven't been on Medicare, there's no resource limit. At 65, the resource limit comes into play at $2,000. The next part of this slide is Community Spousal Resource Allowance. And that is the amount of money that the state says that the well spouse, the community spouse, can keep to avoid spousal impoverishment. So Medicaid actually does have a policy to prevent the well spouse from becoming impoverished, and thus Medicaid allows the community spouse to keep money beyond that $2,000. For benefits that are provided under the COPES program or the CFC program, it is $68,301. That's what the current standard is. That is the minimum. If the ill spouse is going into a skilled nursing facility, the well spouse may be able to keep up to $154,140 as the Community Spousal Resource Allowance. Sometimes we call that CESRA. But what it means is that the spouse can keep a certain level. It's even higher. And this is because Medicaid has a different set of rules for skilled nursing versus community option programs like COPES and the CFC program. So in order to keep that higher level at 154, this is how it works right now, is at the time the person who is ill went into the hospital or then later went into the skilled nursing facility, in order to keep 154,000, they needed to have double that in countable resources. So if at the time of institutionalization, the couple had 400,000 in countable resources, they can keep 154,000. If they had less than double that, I hope I'm not losing you here, then they can't keep the 154. So for example, if they had 200,000, how much can they keep? 154? No, because that's not double 154. So if they had 200,000 in countable, they can keep 100,000. If they had 100,000 in countable, they can keep the 68,000. So Medicaid's rules are really, really detailed, and sometimes they don't follow common sense. And it is for that reason that if you or your spouse or loved one are facing long-term care and you're trying to figure out how can you qualify for Medicaid without having to spend down all your assets, you really want to see an elder law attorney who has expertise in Medicaid benefits. Not all elder law attorneys do. So when you're looking for the elder law attorney, ask them the question, do you help clients qualify for Medicaid long-term care benefits? Is that something that you frequently do, you commonly do? Are you familiar with the rules? Get an idea of how many times have they done this? Do they have, a dozen plus cases that they're working on, or they're just doing one or two? If so, I'd be concerned because this really is an area that expertise is necessary to do a good job. And I think you'll appreciate that as we go through today, because you'll see all of these rules that potentially can help a client keep money. If you don't know what those rules are, you're not really helping out the client the way that the client deserves to be helped. So what I just covered was what can you keep in what do we call countable resources. Something that's really important to understand is that not everything is countable. So let me share with you what's an exempt resource or non-countable. So your home is not countable. There's an exception to a single person if their equity is above 1 point some million. They have too much in equity. Okay. If they have a home that's worth that much, then there's probably other ways that they can draw from equity in the home to help pay for their care or to qualify them for Medicaid if they draw down their home equity. But basic rule, your home is exempt, a single vehicle is exempt, all your personal property is exempt. A life insurance policy with a face value of $1,500 or less. This is a very old rule because that's very unusual to have such a low face value on a life insurance policy. Burial plots, urns, a prepaid irrevocable burial plan is exempt. In certain limited situations, if you own a business and it provides income on which you rely, that business can be exempt. A long-term care insurance partnership policy benefit allows you to keep more money. So that is something to encourage people to buy policies. And what's really important is what we call a SPIA, single premium immediate annuity, a Medicaid compliant annuity. That is exempt. And how you use that is you take money, you buy the annuity, and you've just converted countable assets to non-countable by purchasing the annuity, which we will talk about. So oftentimes when people have too much money, they're looking at reducing their resources. How can you do that? You can buy exempt resources, invest in a home, pay off debt, buy a new car, trade in the old car, buy things that you need, pay for services, legal services, caregiving services. You can even pay for a family caregiver as long as it's necessary, physician documented need for care, and that the payment is made within 30 days of delivery of service. If you go beyond that, that's not going to be an allowed way to reduce your resources. So those are the basic rules. What's another important basic rule about Medicaid? You probably know this. The 5-year look back. Any transfer of asset that was made 5 years before the person applied for Medicaid is not reviewed. It's beyond the 5-year look back window. So if 65 months ago you gave away a home, you gave away assets, whatever you did, created an irrevocable trust, you gave away the assets, that's fine. Medicaid doesn't care. But if you give away assets for less than fair market value, i.e. a gift, within 5 years or 60 months of applying for Medicaid benefits, there is going to be a penalty period imposed, unless there's an exception, which we'll talk about. So for every $11,899 given away, there's going to be a 1-month penalty period. So if you give away $150,000, there's going to be a 12.6-month period of ineligibility. The penalty period starts to run when the person is otherwise eligible. They've made the Medicaid application. And during that period of ineligibility, they must have a way to pay for their care that does not involve the gifted funds. So you're probably going, wow, this is, I don't see any way to preserve assets given what these rules say. Well, let's move on. There are other rules that are really important to know, because there are rules that say you can give away assets and there's no penalty period. So transfers which cause no penalty, already talked about outside the 5-year look-back window. You can give your home away to your spouse, which doesn't really help because both your assets count, but we'll talk about that. To a disabled child, also to a minor child, a child who is a minor, a sibling with an equity interest, or a caregiver child. Now be careful. A caregiver child transfer exemption is really technical. So I want you to be aware of it, but please don't try it on your own. Talk to an attorney, an elder law attorney who has helped a client give away the home to the caregiver child, and with no penalty, then they go receive Medicaid benefits. You can also give away your assets to a trust that's for the sole benefit of what we call a qualified beneficiary. So that's your disabled child, or to any disabled person. It doesn't have to be your child. As long as that person is under age 65, you can transfer assets to a trust for their benefit. Whereas with your child who's disabled, you don't have to give it to a trust. You may want to, you may not, depends on the situation, but you can give away all your assets to your disabled child and there will be no penalty. So rather than having to spend down the assets, you give them to the disabled child, and then you know that those assets are preserved. Now, what they do with those assets is subject to a different conversation, but what I want you to be aware of is that this is a very, very useful rule that allows parents to transfer to their disabled child all of their assets. So I'm not moving around enough. My light has gone off here, but hopefully you can still see me. Let me stop sharing here. There's also the possibility of giving away the person who needs Medicaid to what is called a D4A trust. That has a payback to the state. But it is something that could be quite useful. There's also something called a D4C trust, but that does cause a penalty transfer. And then once somebody is on Medicaid, they should take action to avoid the state's lien. So hopefully you're still with me here. When somebody is on Medicaid, you want to make sure that further actions are taken so that the state doesn't have a lien, because the state does have a lien, or an estate recovery rather, on any assets that remain in the Medicaid beneficiary's name. For example, let's say it was a single person, and of course their house was exempt. They went on Medicaid when they were at the resource level of 2,000 and countable resources, and then they die. Well, once they have passed, the state has a right to recover all the benefits that it paid to this person from that house. As a result, the equity, that value of that house may not go down to the children or whomever the single person wanted it to go to, but instead to the state. So seeing an elder law attorney is really important for single people because there are steps, and I will show you some, that can be taken to avoid state's recovery against that asset. For a couple, there's in Washington really no need for the state to ever have a state recovery if you're working with an elder law attorney, because you're going to avoid a state recovery simply by transferring assets to the name of the community spouse, the well spouse. I need to back up a step because I forgot to share with you one really important exception to the no transfer rule, is that this community first choice program that we talked about a little bit earlier, there's no transfer penalty. It has the income rules and resource rules that you can only, you're a single person, you can only have $2,000. Okay, let's say you have more than that. You can give away all of those assets and there's no penalty. And during the penalty period, there's no penalty for benefits being paid under the CFC program. There will be a penalty imposed for the COPES program. Okay, that's fine. You don't care because your assisted living or your adult family home, or if you're at home, your care is going to be paid for by the CFC program, even though you gave away assets. And the general rule is you can't give away assets without losing benefits. For CFC, you can give away benefits and get CFC to cover your community-based care. One of the things that CFC won't do is cover care if that person's care needs increase, they need to move into a skilled nursing facility. There is not going to be any benefits to cover for the care, and that's a big problem. There should be a plan in place for that, including the person who received the gift to return all of the gift. Because if they don't, Medicaid might cover the care in the skilled nursing facility, but they impose a penalty, 150% penalty against the gift recipient under this hardship exemption. So one of the things that is a very valuable planning tool for those who qualify for the CFC program is a transfer of assets to whomever the Medicaid client would want the assets to transfer to, and no penalty associated with that transfer. All right, so we have talked about avoiding Medicaid estate recovery, and I'll show you some examples of how to do that. So that, in a very quick nutshell, is Medicaid basics. So we have talked about estate planning basics, Medicaid basics. What I want to do now is return to estate planning so we can talk about estate planning documents that are needed so that an elder law attorney can help you either qualify your spouse for Medicaid once you're gone, or during lifetime, a single person or the couple can qualify for Medicaid during lifetime. What is really important to understand in Washington State is that for a couple, the only way they can protect assets for their surviving spouse when they're gone against long-term care costs is if they do it through a will. A revocable living trust might be considered a really good idea for other reasons, but not if the couple's concern is to avoid spousal impoverishment when the first spouse dies. We'll talk about that, but a will is required. A revocable living trust doesn't work. Sometimes after I've made that statement, somebody who wants to look it up themselves, and I appreciate that, says, what's the rule? What's the citation for that? So I actually included it. It's the Washington Administrative Code 182-516-0130. So for estate planning that protects assets, you need a durable power of attorney for finances, one which includes authority to revoke a community property agreement and to enter into a separate property agreement. The power of attorney must have authority to allow gifting, and gifting that is not limited by the annual exclusion amount, which is like $18,000, or is limited to what the dispositive plan of the will looks like. It has to be very broad gifting authority. And typically, the person who is designated to act under the power of attorney for the person who signed the document is the person who would likely receive the gift of the estate during that person, the incapacitated person's lifetime who needs care. So it's really important that the documents specify, hey, it's okay if my agent under the durable power of attorney for finances is the recipient of all of my estate, even if it is against what my will says. Because if they don't have that authority, they can't implement Medicaid asset preservation strategies to protect my estate. So having that authority is really important. I can tell you that if you are not having an elder law attorney prepare your estate planning documents, it is unlikely that these grants of authority will be in that document. Why is that? Because an estate planner or an elder law attorney, even who doesn't do Medicaid, isn't thinking about, I need that to do a Medicaid strategy. Why? Because they don't do Medicaid strategies. So they don't realize why it's so important to have those grants of authority specifically stated in the durable power of attorney for finances. Very important to have that document prepared by an elder law attorney who knows Medicaid. And asset protection, estate planning will not be a revocable living trust. It will be a will, and it will be a will that has a supplemental needs trust in it for the spouse or for other beneficiaries. So I mentioned that we talk a little bit about a revocable living trust. Revocable living trusts are very commonly recommended in different states or by financial advisors because it avoids probate on somebody's death. And if probate's not going to have any benefit, why go through a probate? Totally reasonable. So with a revocable living trust, the person who creates it is called the trustor or the grantor. They typically appoint themselves as a trustee, the person managing it. They're typically the beneficiary of the trust. And the trust says, on my death, all my assets go, to my spouse or whatever. And it avoids probate. So totally makes sense. Problem is, beyond typical problems with a trust and that they're not necessarily funded like they should be or administered like they should be. I'm not going to get into that. But the key problem that I want to point out to you with a revocable living trust in the state of Washington is that if you say in your trust, on my death, all my assets are going to go to my spouse in this supplemental needs trust, my revocable living trust creates for my spouse, state will not honor it because the state will say, if you want to protect assets when you're gone for your spouse against long-term care costs, such that those assets don't count for Medicaid eligibility, you have to do it through a will. This really surprises a lot of people. Estate planners who don't do Medicaid, obviously financial advisors or others who are giving good estate planning advice without paying attention to its bad advice because it doesn't consider Washington's law and Medicaid's eligibility rules. So if you got advice that you should have a revocable living trust, okay, see an elder law attorney because whomever you talk to, may not realize that they gave you bad advice because in other states or in other situations, a revocable living trust might have been a good idea. Certainly at ELG Estate Planning, we do revocable living trusts in the appropriate situation for our clients, but often it's not appropriate. And then we advise the client that a better plan is a will with a supplemental needs trust. Let me show you why. The best way, I think, is to give an example. So let's take a couple, Fred and Betty. They've got a house. It's worth a modest house. It's worth $300,000. They've got retirement, savings, investments, countable assets, and their estate is $1 million. So what happens when the first spouse dies? Let's have Fred pass away first. When Fred dies, Washington is a community property jurisdiction, 1/2 of the million or 500,000 is not going to go outright to Betty. Instead, it's going to go to an asset protection trust, creating this nest egg for Betty. Why is that important? Everything in that asset protection supplemental needs trust created by Fred's will for Betty's benefit is non-countable by Medicaid. So what that means is that 500,000 is there. It's protected. It's for Betty. She's the beneficiary. She can't be the trustee. Somebody else will be the trustee. Usually it's a trusted family member, but it could be a professional. But the point of it is that Medicaid's never going to count that $500,000 against Betty when she needs Medicaid to pay for her long-term care. Having a will with an asset protection trust ensures that that surviving spouse will not become impoverished due to long-term care costs. Is it worth the cost of a probate to protect half the assets, to protect $500,000? That really is more rhetorical because obviously it is. There's also the possibility of protecting more than half the assets. So sometimes we know that one of the spouses is going to be passing. And so in this case, same set of facts. Fred's is sick. He's likely to pass. So we know, for example, that Betty really is going to need long-term care. Fred's been taking care of Betty at home. Betty has dementia. Through their estate planning documents that were prepared before Betty's dementia took over, causing her to lose capacity, they prepared certain documents that allowed her to give all of her assets over to her husband, such that when he died, 100% of the couple's assets, $1 million, is going to fund this trust for Betty. $1 million, all their assets, none of it counts against her when she applies for Medicaid. You might say that makes no sense. This is Washington, it's a community property jurisdiction. Recall when we were talking about the financial durable power of attorney needing to have authority to revoke community property agreements, to do separate property agreements, also to transfer the assets from one spouse to another. That's how we get the opportunity for 100% asset protection. And why that is so important is that the assets, all the couple's assets have been preserved and protected. So when Betty needs to go into a care facility, maybe it does have a private pay period. Okay, she's got $1 million to privately pay, but when that facility will accept Medicaid, she'll be financially eligible. Even if she has $1 million in the trust, or maybe 900 left or 800, whatever the case may be, she is eligible. This is how we get asset protection for a surviving spouse. Keep in mind what that means is that a spouse has died, but having the necessary estate planning documents in place, the will with an asset protection trust is critically important. It's one of our most powerful estate planning tools. So oftentimes people, when they've had their estate plan done, they think, okay, well, I've signed my will, I've got a supplemental needs trust, I know it protects assets, and so I have a trust now. And we need to explain, no, you don't have a trust now because you're both alive. Remember, a will only takes effect when somebody has died. So that's something that is important to understand. A will has no effect until death. So then what happens if you have a couple or if you have a single person and somebody needs care and nobody has died? That asset protection trust that I just explained doesn't help because nobody has died. So then how can an elder law attorney help you protect assets against spend down long-term care costs and get benefits under the Medicaid program? So let's move to what I would say is a little bit more complicated stuff here. And I'm going to start with a single person, then I'm going to move into a couple situation. So I am going to share this slide. And by the way, if you are watching today on this webinar, you will get this, the whole PowerPoint presentation. The only thing I'll say is please don't try to implement these strategies on your own, because I don't give a whole lot of guarantees as an elder law attorney, but I can pretty much guarantee that if you try this on your own, it won't turn out as you wanted it to, because this is pretty complicated. So having said that, you will get the slides, but what I want to share with you is what can we do with a single person? Single people can only have 2,000 in countable assets. If a single person comes to us and they don't have the ability to use a disabled child transfer or other of those exempt transfers, what can we do? So in this situation, the example is that the person is in an adult family home. It costs $6,000 a month. Their income is $3,000 a month, so they're short $3,000 a month. That's what we call the cost of care deficit. In this example, the home is worth $320,000 and they've got $60,000 in the bank account. What are they going to do? What advice are we going to give them? This may be advice we would give them is to take some of that money and spend it down wisely. If you are going to be moving to a care facility, you're going to probably want to sell the home so the state doesn't get the home. If it's going to cost $15,000 to ready the house for sale, do it. If you have an old vehicle and you want a newer vehicle, spend $20,000 on the new vehicle. It has to be in the client's name. If they had an old vehicle, they trade it in. You have to buy it in the name of the client. Say the client can't drive. That doesn't matter. They can still own a car. Somebody's going to be driving that car and taking them to the doctor. Buy a prepaid irrevocable burial plan and use the rest of the money for caregiving and for legal fees. So the client is down to $2,000. We apply for Medicaid for the client and Medicaid approves benefits. They're on Medicaid. What's next? Well, to avoid the house going to the state, we're going to sell the house. This avoids estate recovery and it also preserves assets. I've included on the slide some of how this works. The home sells, it nets $300,000. The person gifts $230,000 and they keep $70,000. Okay, now what? Well, we tell DSHS exactly what we did. DSHS administers the Medicaid program. DSHS imposes a penalty period of a little over 19 months. And during those 19 months, the person's back privately paying. They use the money that they kept. They kept 70. They only need about 58,000. So they have plenty of money to get through the penalty period. Then when they're back down to 2,000, we apply for Medicaid again. They're approved. And what's the result? They were able to preserve $230,000 and the car, and the care was never jeopardized in any respect. That's a pretty good outcome. If it's a couple, let's look at a Medicaid asset preservation strategy for a couple. In this case, the couple has an $800,000 estate. Their house is worth $400,000. They've got countable assets of $400,000. Remember, the house is exempt. It doesn't count. The sick spouse in this case is in a skilled nursing facility, so they qualify for the higher community spousal resource allowance of $154,000. But they're still over-resourced by $245 some odd thousand. What are they going to do? Most people will tell them to spend their money. An elder law attorney who knows Medicaid asset preservation strategies will say, take that extra money, buy a Medicaid compliant annuity. It's a single premium immediate annuity. It's got all sorts of rules attached to it. So it is not the normal annuity. You work with an elder law attorney to make sure you get it right. Otherwise, this strategy doesn't work. So you buy the Medicaid compliant annuity, and all of that money that went into the annuity is going to come back to the community spouse, the well spouse. In Washington State, our term of the annuity has to be 60 months or life expectancy, whichever is shorter. In this case, we're saying it's 60 months. So the result is that by buying the annuity, by buying the annuity, this couple gets to keep all of their money, no spend down. It may say that the couple in the rules can only have $154,000, but they can have $154,000 plus $245,000 in an annuity. So that is a very powerful tool, and I want to make sure that people are aware that Medicaid is not an impoverishment program for a couple if you know what the rules are. So one other thing I think it's important to share with you, that if the person, the community spouse, the well spouse dies before the Medicaid spouse, which sometimes happens, really important that all the assets had been transferred into the name of the community spouse, and that the community spouse has a will with the supplemental needs trust. Remember, with the supplemental needs trust, on death, any assets in that trust are not counted by Medicaid. So by having the right kind of estate planning in place, the couple not only gets the ill spouse on Medicaid, but make sure that they're not bumped off of Medicaid should the community spouse die first. So I know that that was a whole lot, but one of the things that I think is really important for you to understand is that with the proper estate planning, with estate planning that has a focus on protecting against long-term care costs, there's a lot that you can do to protect your assets so that there is Medicaid benefits will come into play without spend down and without impoverishment and without the state getting any assets upon the death of the Medicaid spouse. Checking to see if we've got, all right. I think that questions and answers, my guess, and I've presented on this before, and I know it's quite complicated, and people are probably going, wow, is that truly something that can be done? Yes, it is. We have served literally hundreds of clients with Medicaid applications. So this is definitely something that is worth considering if long-term care costs are something that either you're facing or that you're worried about. Keep in mind that the estate planning documents need to be prepared and drafted before somebody loses capacity, legal capacity, the ability to execute documents. So waiting is not the best strategy. Having estate planning with asset protection against long-term care costs is something that should be done while it can be done. If you want more information, please feel free to reach out to us at Elder Law Group, ELG Estate Planning. In the chat there, we talk about how to reach us. We're elgwa.com. Our phone number is 509-468-0551. You can send us an email at info@elgwa.com. We've got a YouTube channel as well. I hope that you found the information today helpful. We are going to be providing this information to those who attended. And again, if you have any questions, please feel free to reach out to us. Again, my name's Lynn St. Louis, and it was my honor speaking with you today. Thank you so much.